Welcome back. Well, a lot of data and outcome which is expected tomorrow and over the weekend, and ahead of the GST meet, which is expected on Saturday, CNBC TV 18 has learned that the council may take up a proposal to levy 18% GST on corporate guarantee extended by holding companies for subsidiaries. Sources say such guarantee is in fact considered a related party transaction and seen as supply. To discuss this and the other key proposals which are expected in the GST Council and are on the agenda, Krishan Arora, the partner at Grant Thornton Bharat, is joining us now. Whether it makes sense, whether there is a case for levying GST, especially when it comes to corporate or personal guarantee. Mr. Arora, good afternoon. Thank you so much for joining us. Well, that's the first question. Is there a case for levy of GST when there is a corporate guarantee, say from the holding company to a subsidiary? And what is the supply which they are considering here? Is there really a service or supply taking place in this transaction?
Sure. If we have to go back to the era of service tax and look at the way this whole corporate guarantee and personal guarantees, all of the taxation has been there has been absolute ambiguity right from the time before GST as well. So it is important for us to understand what happened before GST came in. Actually, at that point of time, when service tax was a negative list-based taxation, in that there were different interpretation which came out because there was no absolute clarity of whether this transaction falls in a specific category of service or not. They were being compared to typically bank guarantees, which bank typically offers as part of his business when anybody comes to them for any lending activity, etc., and become collateral. Similar to that, when corporates itself have their own companies or parent companies or holding companies, they used to approach the subsidiaries used to approach the banks and or lending agencies for any lending activities. They would typically have a guarantor assurance from their own parent companies, which would act as a collateral. And in that case, there was no consideration actually being charged between, say, the holding company or the subsidiary per se, but the holding company would typically act as a guarantor, and that's what the whole concept of corporate guarantee was. This is recognized under the Indian contract laws. RBI also recognizes this. These guarantees are in the nature of just providing assurance from the entity, the parent entity to the subsidiary, and what basically triggers between that is whether it qualifies as a service or not. And that question came up before the courts earlier as well in service tax. One of the Supreme Court rulings, categorically highlighted that these are not arrangements which should be taxed because there is no consideration per se. However, they did not interpret it to say that there was an element of service in it, but they categorically mentioned because in that particular case, it was mentioned and there was no identified consideration or money exchange between the subsidiary and the holding company to act as a guarantor on behalf of the subsidiary. So in that case, at least there was held that corporate guarantees are not liable to tax, but there was similarly other judicial forums like CSTAT, etc., which actually had divergent views on this matter. Some of them clearly compared it to saying banking arrangements or bank guarantees are classic examples of what a corporate guarantee is. While banks are in the business of providing such guarantees by charging commission, the only difference is when bank is being replaced by a corporate, the difference is that the corporate should ultimately be doing the same activity as what the bank was doing, while there is no consideration which was being charged. And consideration at that point of time was an inherent factor to determine taxation. But nevertheless, in earlier time, it was still a view which was ambiguous, and different judicial forums took different views. And that's the reason why this whole litigation went on and ultimately came as part of GST. Now, what happened under GST? In GST, it became an activity where two parties are involved. There has to be a money consideration, and that activity ultimately should be in furtherance of business. So nothing changed in terms of the scope of this activity as far as GST is concerned. And there was no definition of these activities or inclusion of these activities per se. But what came out was that it is a related party transaction, and any activity, even if there is no consideration under GST regime, is taxable once it qualifies as a supply and is not exempted. Clearly, there was no exemption being provided to such activities under GST, and that's the reason the ambiguity started, and the authorities and the DGGI, etc., investigation started on the fact that similar arrangements of guarantees, corporate guarantees, are already taking place under the GST regime. They are clearly evidence of supplies. The element of supply is there in them, and that's why there is a clear case for taxing them at an 18% rate. Now, having said that, the clarity still did not come because, while one can argue that these are activities which are part of GST, there is an inherent activity which can be a supply because the holding company is committing to do an act on behalf of the subsidiary, and that activity itself is not excluded from the law, and that's why it should be taxed. Having said that, again, there was no clear mechanism in terms of taxing it. There was no clear mechanism of valuing it. And that's the reason why the whole deliberation on the GST Council has happened. There have been numerous representations on this matter. And the case which government is putting forth, and even the law panel of has recommended to GST Council, is there's a clear case that these are taxable activities of providing corporate guarantee by the holding companies to its subsidiaries. And in relation to that, whether the consideration is applied or not, it should be taxed. Number one.
So, Mr. Arora, the main question that comes here in that case is, what is the consideration or supply amount on which this would be taxed? As we said earlier, there is no consideration in the service tax era, and that's the reason service tax couldn't be levied. In this case, what is the amount on which they would tax it, and would there be a presumptive taxation in that case?
So very, very good question, very important question, which is before the council, and that's what is expected to be cleared as far as these clarifications which are expected to come out of the council meeting is concerned. So, there is no specific, regime. If you look at the law, there is a specific, provision under the law itself, which says that even if it's a related party transaction and there is zero consideration, somebody has to look at it from a taxability standpoint by what is called an open market value. Now, what is an open market value for a corporate guarantee? There is no open market value per se which can be defined. It can be only compared to, like I said, bank guarantee. But in case of bank guarantee, the norms or the commission, the basis of commission are defined by the banking channels or the banking rules, that it should look at the way the tenure of that particular guarantee is. It should look at the whole amount at which the guarantee is actually being issued, or the bank actually looks at the risk or the creditability of the particular person who's coming to them for that particular guarantee to be taken. So all those norms are already fixed on the basis of which commissions are decided. It cannot be a case that can be compared to a case of a corporate guarantee, and that has been also held in rulings other than income GST, where it has been said that bank guarantees cannot be compared to corporate guarantees as far as the activity is concerned, and the inclusion of the value is concerned. So that cannot only form as the basis of saying that whatever commission is charged by banks should be same as what corporate guarantees should be valued at, while there are other provisions under the transfer pricing or the income tax rulings which have come, and some of them suggest that 0.5 to 1% of the total guarantee amount could be a valuation which could be adopted, because that is also accepted in international transactions, when these are also considered to be part of international transactions, and the transactions are treated to be related party transactions. The reporting of that happens, in which you can treat it to be a 1% or a 0.5%, and that can be taken as a cue from. But the law itself says one more provision which is very important here. The GST law provides that if the party which is receiving the service is eligible to take full credit on the invoice, on its activities, then whatever value is shown on the invoice cannot be disputed by anybody. It can be treated to be a minimal value at which tax can be charged. That's where the whole clarity is required, because this is a provision which is applicable to everyone except for the cases where credit is not available, like real estate companies, electricity companies, some of the hospital, healthcare. These people do not have the criteria to take credit on their activities. They may not be able to apply this provision, and that's why there is a uniform provision or the uniform valuation which is required as clarity from the government or the council, where this can be completely put to rest in one way or the other. But the cue can be provided on what could be those norms on the basis of which the valuation can be adopted.
Okay, all right, Krishnan, it's been very interesting chat. We had a lot more questions, but we are completely out of time. But thank you so much for providing us that perspective. So a lot of open areas here. Need to understand what could be the value on which GST would be levied as well, and both the provisions for corporate and personal guarantee could be similar as well. But of course, important